All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We're here in our case 1 cv17-0134, Benderra versus State. Each side will have 20 minutes to present their argument. Opponent, you may save time for rebuttal, but how you do that is up to you. You have to manage your own time. The clock at the podium for that purpose. We are recording the argument, so in a couple of days the argument will be on YouTube. As you come forward, please identify your client and yourself so that when we watch the argument we can keep everything straight. We've read the briefs, reviewed the record and confidence of the case, so we're familiar with your argument. So when you begin your argument, just launch right into what you think we need to know and talk about. Counsel, you may begin.
Thank you, and may it please the Court. Andrew Marcantel, representing the appellant, Mr. Hamza Benderra, and to the bench, I am intending to reserve 2 minutes of my time for rebuttal. Well, we're here today to talk about the application of this remedial statute, 13-4051. I think there's another important concept, judges, that needs to really frame our conversation today, and that is the due process rights afforded to Mr. Benderra by the state and federal constitutions, the idea that he is innocent until proven guilty, because after all, I do believe that that is the driving policy force behind this remedial statute. Now,
but he hasn't been convicted, or there hasn't been a criminal process. So I'm not sure why that is important now.
Well, let me address that, Judge. What the state is asking for is while they don't want a truthful notation saying that he's been cleared of charges, what they want is for officers, future hypothetical officers who encounter Mr. Benderra, to treat him differently based on the fact that he has been arrested before.
Well, counsel, are you saying that when counsel walks up, he's going to say, we're going to completely ignore the fact that we never charged him, but we want the officers to know or never convicted, excuse me, he was never convicted, but we want them to know he's been charged at the street level?
I will so assert that, Judge, and I base that not on a hunch. I base that off of the oral argument. At the oral argument level, the evidentiary hearing, the prosecutor gave for some of his reasoning why he wants this, is he wants it for law enforcement purposes. He wants law enforcement to be able to see an unnotated arrest record that Mr. Benderra has.
And due process protects that through what authority?
The Arizona Constitution and the federal Constitution, Judge. It's my view that in the criminal context, nobody should be penalized for.
Where's the penalty?
The penalty is that he's being treated differently because he doesn't have the benefit of this remedial statute. He's being treated differently in the sense that a non-truthful notation, the lack of a truthful notation, is on his arrest record, and so the officer will treat him differently.
I have 2 questions for you. Did
Yes,
you
Judge.
raise this due process argument below?
Yes, Judge. In the oral argument, we definitely discussed these concept of innocent until proven guilty, due process.
No, you're raising a different argument I hear right now, which is regardless of what the statute provides, that the Constitution would provide a right to have this notation made on his arrest record regardless. Am I hearing you correctly?
I'm saying that, Judge, if my client is penalized for the state not being able to, for the state arresting him and not being able to sustain the evidence
Regardless of what the
required.
statute says, you're saying there's a constitutional right to this.
Yes, Judge, I am so assertive.
So even if the legislature had not enacted 1340-51, we would still, your argument would still be the state has to go and make this notation.
I think that this statute flows out of the idea, as I opened with, Judge, I think this statute flows out of the idea that people in this state are innocent until proven guilty and shouldn't be penalized in a criminal context when the state doesn't have the evidence to sustain a conviction.
Well, counsel, I'm confused. I was a prosecutor for many years, and defendants commit many crimes, or the police have evidence that a defendant has committed many crimes, but the state has discretion whether to prosecute for those crimes. They might forego prosecuting on the smaller crimes to go after the more serious crimes. So are you saying that every time the state uses its prosecutorial discretion not to go forward, that they have to make a notation?
Presumably, Judge, when a prosecutor exercises his prosecutorial discretion not to prosecute, it's because he doesn't have the evidence or feels that he doesn't have the evidence.
I don't believe that there are any number of reasons that the state might choose not to prosecute that have nothing to do with the evidence.
Understood, Judge. And I just want to, I'll leave the due process argument at this time.
Can you show me in your brief where you make this argument?
Judge, I do think it more stems from the oral argument, the transcripts of the oral argument.
You're asking us to rule now based upon some allusion in your oral argument below that you didn't put in your pleadings and that's not contained in your brief.
I also believe that it's a non-waivable right. It is a fundamental right, and so I do believe that the court has discretion to rule on that.
What is the fundamental right? I mean, I think that's what we're asking. What is the fundamental right?
Not to be deprived of, not to be treated differently because the state wrongfully arrested you. Basically, because he was arrested and because he's being denied.
Isn't that the issue? The issue, as I saw it walking in here, is where's the burden to prove a wrongful arrest? That's the interest. Well, I don't know how interesting it is, but that's the issue that we have before us.
Understood.
So you're asking us to assume that if there's a wrongful arrest, regards to the burden, that there's a constitutional right to have that notated on your arrest record.
I believe so, Judge. I would like.
And are you saying that if the state chooses not to prosecute, that the arrest magically becomes wrongful?
I wouldn't say it like that, Judge, but I don't.
How would you say it?
How I would say it, Judge, is I don't believe that people should be penalized whenever the state cannot carry their burden in a criminal context.
Well, but unless the state prosecutes the case, we never know that.
Well, this case in particular, Judge, I would like to talk about the evidence in this case, because the strange position that the state is taking is that we didn't have enough. Admittedly, it's undisputed that they did not have enough to prosecute the case. So the question then becomes, how much evidence is enough to deny somebody the benefit of this remedial statute? Because if you analyze the evidence, I think it's necessary at this point to point out a few factual problems with the answering brief in this case, in which they refer to the spice that was found in Mr. Benderra's car as contraband. That spice was tested, as we discussed at the oral arguments, Judge, and it was found not to match any of the illegal drugs whatsoever that they could test for. And they did not retest it, and their discretion to do so was their own.
So the officer on the scene would have to actually test it before he prevented the detainee from going any further and took him to the detention area?
Not so, Judge. In the oral argument, the officer said on the stand, and you can read the transcripts that we've attached, that he's familiar that the term spice is a commonly used term that can refer to all kinds of substances, legal and illegal. And furthermore, the packaging in which this spice was found in the car, with an illustration on it and a barcode, and looked like it was for commercial sale, showed every indication that it was legally purchased in a store. So there's lots of other factors, Judge. I don't think it's quite necessary for him to drug test it on the scene, though whenever that is available, and I understand they can field drug test lots of things now.
Go ahead.
Well, counsel, so you had a hearing on this issue where evidence was presented, correct?
Yes, Judge.
And the trial judge disagreed with your position and found that there was sufficient evidence.
Yes, Judge.
Correct. So what's our standard of review? Because the trial judge heard the evidence, saw the witnesses, and could judge credibility, and the trial judge found that you didn't make your case that your client should be cleared. That's, I assume that's an abuse of discretion. I'm not sure how we can gainsay that.
I understand the court's point, but I think the standard of review lies in how the trial judge defined wrongful. I think that the trial judge made a decision that wrongful meant an unconstitutional or illegal arrest. And he determined that, I believe...
Doesn't that make sense?
It does, Judge, but as the courts show us, and as the Muhajirin, I hope I'm pronouncing that correctly, the Muhajirin...
We've been debating how to pronounce that.
Muhajirin decision, I'm going to go with that, tells us is that it's not just an unconstitutional arrest. There's other things out there. One of the ways that somebody can prove that their arrest was wrongful was to prove that it was unjust. There's all kinds of other language. So it's not just limited to an unconstitutional arrest, though I certainly agree that an unconstitutional arrest is certainly a wrongful arrest. This seems to be a good time to reiterate. Oh.
Well, so if the police have probable cause to arrest someone, then isn't that enough?
Well, Judge, first and foremost, I think this is a good point to say that we do not concede, and we mentioned this in our brief and at the lower levels, we do not concede that this was a constitutional arrest. As we mentioned, it wasn't contraband at all. It was tested. The officer had reason to know this and testified that on the stand. The deception that took place that formed the basis for his alleged probable cause was established, or at least strongly argued by our side, to be a result of the fact that English is not his first language. He's a Moroccan immigrant, and he was having a hard time understanding the officer. It's important to look at the state's wording and the officer's phrasing of this deception. Notice he never says that Mr. Benderra lied to him, which actually could be a crime in certain contexts.
Well, come on, there was a lot of evidence addressing the fact that he misrepresented to the police how much money he had on him. He misrepresented to the police the purpose of his trip. He misrepresented any number of things. So at what point can you say that your client was just, clean as the driven snow and was taken advantage of by unscrupulous police officers? How do you get there?
If you don't understand English, Judge, you might be answering anything to anything at that point. You might understand, do you have money, how much money is there? You might understand that to mean in your wallet, in your pocket, in the glove box. You could understand it to mean numerous things.
So as long as you're a non-speaking English person,
well,
any stop that does not result in a prosecution is a wrongful stop.
Judge, that really depends, and I think that the Muhajirin court and the Franco court show us differently those precedents. But let me just say this to try to respond to your previous point. I try to imagine myself if I was pulled over in another country and I had an officer asking me a lot of questions. I wouldn't know. I would try to oblige the best I could, but I would likely seem quite deceptive afterwards as everything's being analyzed. So
what if the dogs were brought out and they alerted on the $25,000 extra dollars that you told the police officer you didn't have? Would that be a basis for the authorities in that country to be concerned about what you were involved in?
I don't think that's enough, Judge. I really don't think that is the alert alone at that point, given that he's not confronted with any contraband whatsoever. I would be, if this was in the pretrial phase, I would file a motion to suppress the arrest as unconstitutional.
And what would be the response of the court?
I would hope that the court would find that there was insufficient evidence, that there was no crime committed, that there was everything that was seized by the officers was completely legal for him to own. He was a store owner. He was this was all product for his store. It was money he's allowed to carry.
What store did he own?
He owns a shop. It's a smoke shop, Judge.
I thought it was a candy and gum shop.
It's a smoke shop. He also bought candy and candy and gum. And my understanding was they were among the items.
So the bottom line at the end of the day is you don't make the stop and then proceed with collecting additional evidence and prosecuting unless you can prosecute him at the time of the stop. It's a wrongful stop.
I wouldn't say that, Judge. I'm not questioning the stop. I'm questioning the arrest as unconstitutional. And keep in mind, too, that and this was kind of a side point, because while I do argue that it was unconstitutional, it doesn't just have to be unconstitutional in order to fall under the purview of this statute, as made clear by Mohajer.
Let me see if I can steer you to what I think you need to respond to is, okay, so your argument is that the trial court said wrongful, and you're saying that wasn't enough because it could also be unjust. So tell me, what exactly are the facts that make this unjust, such that in our standard of review we would find the trial court erred?
So, Judge, that all comes around the question of how much evidence is required to deny somebody the benefit of this remedial, this liberally construed
But the statute, do you agree
remedial
the statute and our case law say the burden is on you to prove unjust?
Correct, Judge.
Okay.
And even if the trial court correctly determined that there was probable cause in this case to arrest, all of the evidence, I think what the trial court did is they excluded the possibility, as Mohajer counsels, that it could be something more than just an unconstitutional arrest.
Right.
So the
fact
fact
that. So what beyond an unconstitutional arrest makes this unjust, such that we would say it is wrong to have this on his record?
So let's get some guidance from the other cases that we have been talking about. Mohajer, the evidence was such that it was strong enough to support an indictment. They were able to put it in front of a grand jury, and the evidence was able to procure an indictment because of the testimonial evidence and all of the different evidence in the case. It's much stronger than this case, where everything recovered from the car was completely legal to own, no contraband whatsoever.
And what about your facts make it unjust for anyone to look at his record and say this guy was arrested under these circumstances?
No contraband discovered whatsoever, no clear indicia of a crime. The state immediately upon our motion returned virtually all of the property, with the exception of one cell phone, which they then returned afterwards after they concluded their investigation that there was no criminal contact whatsoever. So I think it's just, I think it is so, the question is, when can somebody use this statute? And I think that this falls under that baseline of total lack of evidence of a crime, at least even if you think that the initial arrest was warranted. Now we've looked at it, and now we've seen that there's not evidence of any crime whatsoever. Everything's been tested. Everything's been looked at. What do we call it at this point if they don't have the evidence to secure even an indictment? And I think that this falls below both the evidence in Mohajer and in Franco.
So you're saying that the way the state escapes the obligation to impose this, to act under this statute, the way they avoid having to clear the record is by obtaining an indictment. Because anything less than an indictment, there wasn't any basis. Is that right?
Well, I think it's a case-by-case basis, Judge. I wouldn't go that far. But that is certainly one way, or could be one way. But I think it's more of a case-by-case basis where we see how much evidence after the arrest, after the smoke is cleared. Let's see how much evidence of guilt there actually is in the case.
You're asking us to view a lot of the facts regarding his statements and what his statements through a lens that says consider the cultural and everything, all those other differences. But didn't the Superior Court have that same information? I mean, they knew his history, how long he'd been in the United States, what his business relationship was. I mean, you posited if I were visiting a foreign country. This is not someone visiting a foreign country. This is someone who has a business and lives here and presumably has lived here for some lengthy period of time, right?
That's correct, Judge.
So why would we substitute our judgment concerning all those facts for the Superior Court's judgment knowing those same facts.
Understood, Judge. And it's because we are arguing that the Superior Court erred in how it defined wrongful. And we think that the judge on the Superior Court level looked at everything and determined, you know what, I think the arrest was supported by probable cause. It was a constitutional arrest. So therefore, he does not fall under the purview of that statute. And to the panel, I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel. Counsel?
Thank you, and may it please the Court. My name is Benjamin Kreutzberg, Deputy Yavapai County Attorney representing the state in this case. As the panel has described, the important issue in this case is whether the arrest was wrongful. That is what Section 134051 requires for any relief to be granted. The case law, Franco and Moajeran, again, I'm not sure I'm saying that correctly, quite clearly requires a plaintiff in this type of case to prove both that the arrest was wrongful and that the interests of justice require that the arrest record be cleared. Moajeran identified one possible way to do that as by showing actual innocence, and that has not happened here. Mr. Benderra has argued that the state's evidence was insufficient to prove the crime, but that's not remotely the same thing as himself showing that he was actually innocent.
So what you're saying is that in this case, having brought this action, it's the appellant's responsibility to show us what?
To show that the arrest was wrongful and that the interests of justice require clearance of the arrest record.
And was anything presented by the appellant in that regard?
No. And I don't think that the appellant, if the appellant could rely on the state's evidence, I suppose that could conceivably show that, but in this case there's no evidence to show actual innocence or some other form of wrongfulness in order to carry that burden. He's taken issue in some of the briefing with the idea that he's required to prove the elements, but this is not a criminal action, it's a collateral civil action, and there's nothing remarkable about a plaintiff in a civil action being required to bear the burden of proof. The citation to cases about the presumption of innocence is just not applicable to this type of situation. The facts here amply support that the arrest was non-wrongful. We've described it. He was driving without a license plate. The registration document was concealed.
Before you get into the facts, could
Sure.
you respond to his assertion that the trial court applied the wrong standard in defining wrongful? So in other words, he argued that trial court looked at it as just whether was the stop or arrest constitutional and didn't go to that second step of whether there's something beyond that that is required.
I disagree. When you look at the trial court's minute entry and the evidence presented at the hearing, it was considering both what was happening at the time of the arrest, and it even made the finding that justice didn't require clearance, which is similar to this idea of there's no wrongfulness. So I think the court got into the important pieces beyond just what happened at the time of the arrest and probably saw that there was nothing presented that showed that there was any kind of wrongfulness or actual innocence.
If the police officer has probable cause to arrest the defendant, regardless of whether the state prosecutes him or not, the arrest would be constitutional, and I assume that it would be not wrongful. Is there anything more to wrongful other than whether it's constitutional, which of course would include sufficient evidence for probable cause?
I would like to be able to say that's the end of the story. I think Moajeran would go a little bit further than that. There could be situations where if a defendant, or in this case a plaintiff in a 134051 action, could come forward and very clearly demonstrate that it wasn't him, they had a mistaken identity, something like that. I think even if there was probable cause based on the situation, then it might be appropriate to have an arrest cleared under those circumstances.
Sure.
So I think it is possible, but I think it's a fairly significant burden that a 134051 plaintiff would have to overcome in a situation like that, to overcome that if an officer has probable cause, that's a constitutional and legal arrest. and I won't belabor the facts, but they amply support the idea that the arrest was lawful, and I think non-wrongful. There was, at the very least, inconsistency in Mr. Benderra's statements. He was possessing spice, even admitted that he was. Whether or not that's legal, I think it is important for an officer to have the discretion to say, I don't know, we may have to get this tested in order to determine whether this is a crime. And there was also a pipe with residue. And as was mentioned, there was a dog alert.
He made some statements regarding, during his argument regarding the testing. Could you clarify exactly what happened with respect to the testing?
I'm not aware of exactly what happened in terms of which lab and what tests were performed.
And let me rephrase the question. Was it that the test results came back as it wasn't something illegal, or did the test come back as we don't have a sufficient enough sample to do full testing?
My recollection from the briefing is that there was too small of a sample for there to be enough to determine with precision whether what substance it was. I do not recall specifically, but I believe that
I could look at the record.
I believe our brief addressed exactly what the testing was done. The Superior Court made the factual determination that the arrest was lawful and not wrongful. And the court, the cases, specifically Moa Jaron, talks about it being an abuse of discretion review for that type of factual finding. And there's certainly nothing in the appellate record that would disturb that, that would compel a finding of abuse of discretion. Separately, even if there were some sort of wrongfulness, Moa Jaron also recognizes that the interests of justice could still allow the denial of a petition for the clearance of records. I would particularly point to, it's a footnote, footnote 6 of Moa Jaron. This is a direct quote from that footnote. I'm sorry, that's the wrong footnote. Footnote 4 is the one I'm talking about. Where a trial court has discretion to determine whether to grant relief even if the arrest were unlawful. Now, the specific factual situation it was considering there was the possibility that there could be some sort of technical defect in the arrest, but come up with something that was still warranted. What that emphasizes, though, is that the trial court, and by extension the courts in general, are looking at the interests of justice. In this situation, there's just nothing about this situation that was unjust, which is similar to unlawful, but not exactly the same. So even if there were, I'm sorry, I'm getting my terms confused. Even if there were something that was technically wrongful, if it were not unjust to clear the records, it wouldn't make sense to do so. Fundamentally, the lack of a charge simply does not make an arrest wrongful. Footnote 6 of Moa Jaron recognized, and this is the quote I was going for, the mere fact that charges were dismissed, of course, does not itself prove the alleged crimes did not occur, just as an acquittal does not establish a defendant's innocence. And this situation where charges were not filed is exactly the same thing. In the briefing, Mr. Benderra takes some issue with the collateral consequences that would allegedly attach to an arrest record, and I think there's been some discussion about that in today's argument. But Franco and Moa Jaron reject the argument that we should make a cleared notation specifically based on those collateral consequences. Paragraph 25 of Moa Jaron says, this is another quote, as Franco demonstrates, limited employment opportunities are not a sufficient ground for relief under the statute. Wrongfulness is the threshold issue to be decided under Section 134051. Another concept is the idea that without a notation of clearance, these records would allegedly be incorrect. But the statute calls for not a notation that no charges were filed, but a notation of clearance. That notation would be inaccurate in this situation because law enforcement never cleared Mr. Moa Jaron, they just didn't move forward with formal charges. If nothing changes, there will be no indication of a conviction on the record, so leaving it untouched would maximize its accuracy. Just touching briefly, I don't think that the due process argument was adequately raised in the briefing, and even if it's not absolutely waived, I think prudentially this court should decline to consider it because it's not been properly briefed. Even if we were to consider that, I think the analysis would be the same because there's simply nothing there to suggest that the arrest was sufficiently wrongful for due process to require clearance. Fundamentally here, there was a non-wrongful arrest, and Mr. Benderra advanced no evidence of his innocence or the arrest's alleged wrongfulness. He solely relies on not being charged with a crime. The law simply does not require the state to alter its records to say that he was cleared in this situation. I'd be happy to answer any other questions, but otherwise I have nothing further.
No. Thank you, counsel.
Thank you.
Just briefly in rebuttal. The state asserts that we presented no evidence whatsoever at the lower court level that Mr. Benderra was actually innocent. Yet, it was established in both of those oral arguments that the state never discovered any contraband whatsoever, never discovered any drugs. The resin in the pipe was not determined to be contraband. My recollection is different from that of the state's, and obviously the court can check the briefings with respect to whether the quantity that was tested of the spice was simply too small. I believe it was large enough for a test, and they actually all showed negative, but I encourage the court to review that. So I think that alone is plenty presentation of evidence saying, okay, now that regardless of what you think about the arrest, was the arrest lawful, was it unlawful, regardless of what you think about that, the smoke is cleared, and now we see that there is clearly no evidence. There's clearly no evidence of contraband. Everything was returned to him without much of a fight from the state, and the reason is no crime was committed here. So all the evidence points to the fact that we have an innocent man. I think that with this threshold of evidence this low, which falls far below that of the evidence in Mohajeran and Franco, that he should not be disqualified from this remedial statute.
Thank you, counsel.
Nothing further. Thank you.
Thank you for your arguments today. We'll take this matter under advisement and issue a decision in due course. We stand adjourned.